A new class action lawsuit was filed against ALO Yoga and several social media influencers, accusing them of deceptively promoting ALO's products without properly disclosing that the influencers were paid or compensated, thus violating federal law and consumer protection statutes. We're going to dive into what the FTC requires influencers to disclose, how ALO and the influencers are alleged to have conspired to hide their financial ties, why this lawsuit is structured as a class action, and most importantly, what influencers and brands should be doing to avoid ending up on the wrong side of lawsuits like this. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner, Tara Sattler. We are going to talk about influencer marketing gone wrong on today's installment of The Briefing. Tara, welcome back to The Briefing. It's good to have you as always.
Hi, Scott. Always like to be here.
Yeah, I think this one's a real interesting one. So today we're going to talk about Susli versus Alo Yoga. It's a class action lawsuit that was filed in federal court in Illinois. It targets not only the brand Alo Yoga, a super popular athleisure brand, but it also targets about 15 influencers who promoted Alo's products on Instagram. The plaintiffs allege that these influencers failed to disclose their material connections to Alo and that Alo actively encouraged that failure.
Exactly, Scott. The plaintiffs claim that they and others like them paid a premium for aloe products based on what they thought were genuine, organic recommendations by these influencers. But behind the scenes, those influencers were allegedly being paid, whether in cash, gifts, or other perks, without telling customers. That failure to disclose violates FTC rules and, they argue, consumer protection laws in states like Illinois and California.
Okay, so we've covered this previously on our podcast, but let's kind of do a little recap here. So let's dig into that FTC framework. So Tara, what exactly does the FTC require influencers to do?
So, under the FTC Act, deceptive advertising is illegal. The FTC has issued very specific guidelines, especially in its Disclosures 101 for social media influencers document. The key points are one, clear and conspicuous disclosure. If there's any material connection between the influencer and the brand, meaning any relationship that could affect the weight or credibility of the endorsement, it must be disclosed. This includes cash payments, free products, free trips, discounts, even a brand sending a product for consideration.
Right. And the other key point is that placement matters. The disclosure must be hard to miss. It must be conspicuous. It must be placed so that consumers will see it before or at the same time as they see the endorsement. Disclosures cannot be hidden in a long string of hashtags or buried deep in a caption. For stories or short videos, the disclosure should appear visually, superimposed on the screen, not just mentioned verbally or implied.
And the third point is that language matters. Vague disclosures like, thanks, Aloe, are not enough. Phrases like hashtag ad or hashtag sponsored are examples that the FTC says are sufficient. Simply tagging the brand isn't enough to disclose the material relationship, though.
Right. So it's not just about mentioning the brand, it's about being crystal clear that there is compensation or some other material tie between the influencer and the brand.
Exactly right. So the test is whether a reasonable consumer would understand that the endorsement is a paid promotion. If not, it's considered deceptive under FTC standards.
Okay. So as I said, we recorded an episode that was a fairly deep dive into the FTC requirements, and we're going to post a link to that episode in the show notes. But now let's move on to the key part of the complaint: the allegations that Allo and the influencers worked together to hide these material connections. So, Tara, what exactly are the plaintiffs saying Allo and the influencers did?
They're really alleging a pretty elaborate scheme. Here's what they claim. Influencers were shown using and loving aloe products, posting about them as their favorites, but these posts didn't include any disclosure. No hashtag ad, no sponsored tags, nothing that would tip off consumers that this was an ad. This created the illusion that their endorsement was unbiased, when in fact it was bought. The complaint also claims that Allo allegedly encouraged or allowed influencers to omit these disclosures as part of a strategy to make endorsements appear authentic and organic.
So that's really important because if it's true, it's not just a passive failure to make these disclosures, it's an active misrepresentation, and it's actually a conspiracy to make that misrepresentation between both Allo and the influencers. It's not just that they forgot a hashtag, it's that they allegedly designed the post to look authentic when they were not.
Right. And that's why the plaintiffs allege not just violations of the FTC Act, but also consumer fraud, false advertising, and even unjust enrichment.
Right. The complaint alleges that Allo and the influencers went to great lengths to hide their commercial relationship. The complaint says that because Instagram's algorithms might flag and reduce the reach of sponsored content, Allo and the influencers purposely avoided using official ad disclosures to maintain higher engagement and reach. That's pretty devious.
That is a pretty elaborate scheme.
Yeah. Yeah. Okay, so let's pivot to something practical. If you are an influencer or a brand working with influencers, let's talk about what you need to do to avoid being a defendant in a lawsuit like this.
Sure, there's definitely a roadmap for doing it right. For influencers, always disclose any material relationship clearly and conspicuously. Use obvious hashtags like hashtag ad, hashtag paid partnership, hashtag sponsored, and make it clear in the caption, don't bury it. And make sure that disclosure is visible on stories and short form videos too. Also, be honest about your relationship. If you got free products, just say so. And err on the side of over disclosure. When in doubt, disclose.
Right. Those are really good points. And brands have even more responsibility under FTC guidelines. A brand really can't just hope that an influencer properly discloses. A brand should require in their contract between a brand and an influencer. Well, let's take a step back. A brand should have a contract between the brand and the influencer. And in that contract, the brand should mandate clear, compliant disclosures. Uh, it might not be a bad idea to train influencers on disclosure rules. Um, I don't know. I go back and forth on this one. If you have training and provide influencers with training documents, then I could see that actually being used against the brand in a lawsuit. But I mean, it's really not a bad idea if an influencer doesn't really understand or know what disclosures are required to maybe provide an example in the contract. And then monitor influencer postings to ensure compliance and make sure that contractually you have the right to force the influencer to take the post down and fix any issues. And so, having the ability to take corrective action uh, is very important. Brands just can't play dumb. If they know an influencer is failing to disclose and a brand doesn't do anything about it, the brand is on the hook too.
Exactly. Under the FTC endorsement guidelines, brands are liable for misleading representations made on their behalf if they knew or should have known about the deception and failed to correct it.
The takeaway is clear. Transparency is not optional in influencer marketing. Failing to disclose a material relationship can create massive liability, massive, not just for the influencer, but also for the brand. And as the Aloe Yoga lawsuit shows, this kind of liability can turn into a nationwide class action lawsuit with tens or even hundreds of millions of dollars at stake.
The class action lawsuit in this case seems pretty elaborate and far stretch. So I think it'll be interesting to keep an eye on this one to see what facts come out in the process as this case progresses.
I mean, it's kind of mind-blowing that Alo Yoga or their marketing department or their outside agency and the influencers, um, at least as it's alleged, conspired to hide the material relationship between the brand and the influencers in order to get better reach from these posts and avoid and evade Instagram's kind of, ad detector algorithm. And that is really, if that is proven to be true, um, it's going to be really bad. It's going to be really bad for Aloe, more so than the influencers, because I assume that the influencers probably are judgment proof. So it's going to be really bad for Aloe because Aloe is not judgment proof.
Yeah, it's hard to believe that they thought that this was worth it if this is really what they did.
Yeah, well, we'll see. We'll see what happens in this case. So that's it for today's episode of the briefing. Thanks to Tara for joining me today, and thank you, the listener or viewer, for tuning in. We hope you found this episode informative and enjoyable. If you did, please remember to subscribe, leave us a review, and share this episode with your friends and colleagues. If you have any questions about the topics we covered today, please leave us a comment.